Hello everyone, I'm Apurva Pandita and welcome to LiveLaw. As we all know, the Shiv Sena dispute had captivated public attention and sparked wild speculation. The outcome of the long-awaited verdict on the Shiv Sena party's internal rift has finally come out on 11th of May 2023. It holds immense significance not only for the Shiv Sena party but also for the broader political landscape. For quick background, the Thackeray faction had requested for the restoration of status quo ante so that the parties were restored to the same position as it were before. But on 11th of May, it has been declared that the Supreme Court could not order the restoration of the Uddhav Thackeray government due to the leader's voluntary resignation before the floor test. However, the bench made a resounding statement by declaring that both the governor's decision to conduct the floor test and the Speaker's decision to appoint the whip were flawed and incorrect. The Nabam Rabia judgment has also been referred to a larger bench. More specifically, with regard to the issuance of notice, the question is, does the mere issuance of a notice to remove a speaker restrict the court from adjudicating disqualification petitions under the 10th schedule of the Constitution? After referring the same to a larger bench, they also made it clear that the Nabam Rabia case did not directly come into play in the present proceedings. The esteemed Constitution bench led by Chief Justice of India D.Y. Chandrachud, along with Justices M.R. Shah, Krishna Murari, Hima Kohli and P.S. Narasimha began hearing the case on February 14, 2023. After much anticipation, the judgment was finally resolved on March 16, 2023. Coming over to the judgment pronounced, as to what exactly does the judgment say? Well, first of all, the Supreme Court ruled that the Speaker's decision to appoint Mr. Govt as the whip was not allowed. The court said that elected legislators have a duty to hold the government accountable and the procedural mistakes cannot be hidden under Article 212 of the Constitution. The court said that if the legislative party appoints the whip, it would disconnect legislators from their political party. This could lead to factions breaking away and causing problems. The court criticized the Speaker for not knowing which person, Mr. Prabhu or Mr. Govt, was authorized by the party to be the whip. The bench then also emphasized that no faction or group could claim to be the original party in defense of disqualification proceedings. To understand better, let me give a quick background. The Thackeray faction had argued that the Shinde faction never claimed there was a division within the party. Despite this, the Election Commission of India had recognized a split in the party. They pointed out that the 10th schedule of the Constitution did not acknowledge a split as a defense against disqualification, and the only defense against disqualification was merger with another party. Para 3 of the 10th schedule, which accepted split as a defense, was removed by the Parliament. And now the Apex Court has held that the defense of a split was no longer a viable option under the 10th schedule. Any defense would now have to be based on the current version of the 10th schedule, leaving the political landscape brimming with uncertainty. Moving further, the court has further stated that governor's actions were not in line with the Constitution. With flair and conviction, the bench had declared that the governor had no grounds to doubt the government's confidence as no confidence motion was issued by the opposition parties. The resolution relied upon did not indicate a withdrawal of support, and the dissatisfied MLAs constituted only a faction and not the majority. The court asserted that a floor test could not be used as a tool to settle internal party disputes. The governor had no authority to meddle in the political arena or interfere in the inter-party or intra-party conflicts. They highlighted that nothing prevented Mr. Fadnavis and the 7 MLAs from moving a no-confidence motion, emphasizing that this avenue remained open to them. Talking about the twist that left the Thackeray faction disappointed, the Supreme Court made a decision while examining the relief sought by the faction and held that the restoration of the status quo ante was off the table, that it could not order the restoration of the Uddhav Thackeray government. Why? Well, it turned out that Mr. Thackeray had taken a detour and skipped the crucial floor test before tendering his resignation. This left the court with no choice but to deny the request to restore the former state of affairs. And with that, the court upheld the governor's decision to administer the oath to Mr. Shinde, who had garnered the support of largest party, the BJP. With this, we come to the end of this video and we really hope that you like our content. And if you do, then do not forget to like and subscribe to our channel. And for more legal updates, keep watching LiveLaw.